Yeah, right. Well, good evening, Aaron, Gothelf, and good morning to viewers in the UK. I'm delighted once again to be co-hosting the fourth in the series of podcasts ADR across the globe, and we're joined today by the regional vice president of the American Arbitration Association's commercial division, Aaron Gothelf, who is based in San Francisco in California. I'm delighted to welcome you to the podcast, Aaron.
Thank you, Tony. Thank you, Chinwe, as well.
Hi.
Thank you. Yeah, Aaron serves as the national chair of the AAA's entertainment practice, the Western U.S. chair for the Arbitration Association's technology practice, and an ambassador for the AAA-ICDR Foundation. He's a council member for the ABA's dispute resolution section, a very important section of which he formerly served as educational programming officer, and as chair of the ABA's forum on the entertainment sports industries, motion picture and television division. He's a member of the ADR committee on the litigation section of the California Lawyers Association, as well as a rotating host for another podcast series, the ABA podcast series, actually named Resolutions in this modern age, with its focus on dispute resolution. Chinwe and I are delighted, Aaron, that you found time to join us today. And without further ado, let's go.
It's an honor having you here, Aaron. So without further ado, the first question is, what AI tools has the AAA developed over the past few years? Thank you.
Well, we've been developing all sorts of different things. We about a little less than 2 years ago, we got a new president and CEO, former Michigan Chief Justice of the Michigan Supreme Court, Bridget McCormick, who's a real AI futurist and wanted to take organization really into the AI world. It's really interesting what's kind of going on at AAA, because there are not a lot of legacy companies or companies our age that are really pivoting so quickly to the AI world. Fun fact, the AAA turns 100 years old next year.
Wow.
And so we're very proud about that.
Congratulations.
Yeah,
Yeah.
yeah, no, it's I can't think of a lot of American companies in general that make it to 100 years old. So let alone, a company in the dispute resolution space where, a lot of dispute resolution is areas have recently kind of been created, right? It's not like people have been formally, I guess, mediating and arbitrating cases for hundreds of years. I guess informally, maybe. But so we're really proud about that. So we developed a number of AI tools, and we kind of have rolled them out over the last year and a half. Some of them are in more final form. Some of them are still kind of in beta form. Our first one was Clause Builder .ai, and anybody in the listening audience can type it in, clausebuilder.ai, and actually go to the website and beta test it with us, if you will. So for many years, we had a website called clausebuilder.org. We still have that website where parties could go and they could, through answering a series of step-by-step questions, create an arbitration provision for a contract that they could simply copy and paste. I teach arbitration clause drafting when I get a chance to lecture in law schools and things like that. I've got to say, it's funny how somebody might spend, you know, many hours drafting a 200-page contract, right? But when it gets to the arbitration provision, it's buried somewhere on page 87, like clause C2, and it's like one really poorly drafted sentence. And while nobody wants to think that there's going to be a problem in the life cycle of their contract, if there is an issue, that really bad arbitration provision could really spell a lot of trouble for the parties. In any event, clausebuilder.ai is essentially like other LLMs. You type in a prompt and you might say, for example, draft an arbitration provision for a software as a service contract to be heard by a single arbitrator in San Francisco, right? And it'll put a statement like that just in the correct legalese, right? And then I might add something like add California as the choice of law provision, or add a cost shifting provision or something like that in there for the prevailing party. And I just have to basically just say that, and then it'll know how to properly format it. So we're really excited about that, and that's something I like to play around with. Again, clausebuilder.ai. Um, Both internally and externally, we have AAA AI arbitrator search, right? So in the past, when the parties were looking to select an arbitrator, we could create essentially a search link for them where they could go and they could see basically all the thousands of arbitrators we have around the country. They could search by keyword, they could search by region, by profession type, whatnot, and you can still do all that. But the arbitrator search used to be what's called um, it was called just a regular keyword search. It wasn't a semantic search, right? AI uses semantics. So I'll give you just a very basic example. Let's say I have a construction defect case, right? And I need an arbitrator experienced with stadium construction defect uh, incidents, right? Um, and in the old days, I would simply type in stadium, and every arbitrator that had the word stadium in it would basically just pop up, right, in their resume. But what if one of the arbitrators, who turns out would make a great arbitrator, doesn't use the word stadium? What if they use the word arena? Well, in the old days, that arbitrator's resume wouldn't come up in any search, right? Because I'm searching for stadium. But a semantic search and using AI recognizes that in many situations, the term stadium and the term arena might actually mean the same thing, or coliseum or something like that. So that's not only helping the parties find arbitrators, it's also assisting our case managers when they're putting together rank and strike lists. And this is giving them a broader width, if you will, of resumes to choose from. We have a AAA rules chatbot. Our rules have been in just the regular paper form up on as a PDF on the website forever, right? But now we actually have a chatbot you can interact with. We also have an AI chat book, which is especially useful for pro se litigants, where not only does it explain kind of the rules, but it actually also explains the process of how one files an arbitration, what happens during arbitration, et cetera, et cetera. Things that somebody, a non-attorney, might not completely understand. And then, of course, we'll talk about this a little bit later, but we're the first major ADR provider to come up with an actual AI arbitrator, which is something that we're really excited about.
Oh, interesting. Thank you so very much. I just want to ask this all important question. So how do these tools expand access to justice?
Okay, that's a great
Thank you.
question. And so overall, most of these tools make it essentially easier for pro se litigants to understand the arbitration process and hopefully get a more fair result, right?
Mhm.
One of the criticisms of arbitration, especially consumer arbitration or employment arbitration, where maybe somebody didn't have the opportunity to um, avoid clicking on the click wrap that they accept consumer arbitration, or in a employment contract accept employment arbitration.
Yeah.
It's that it's somehow manifestly unjust, because typically a lot of times the claimant in these situations is a pro se litigant and the respondent is represented by counsel, right? And then there are issues of fairness around that. So all these tools, I think, make the process a lot more easy to understand for litigants that might not have a legal background. And another thing that I'd want to add too is it really helps keep the arbitrators out of trouble, because one issue with pro se litigants is, as an arbitrator, when one side's represented by counsel and the other side isn't, you have to really do your best to avoid giving any type of legal advice to the pro se litigant. And pro se litigants ask questions all the time that really border on legal advice, like, well, what should I put in my brief?
Mhm.
What if you've asked for me to revise my claim? What do you need to see in my claim so I can win my case? Questions like that are really inappropriate to ask the arbitrator, who's going to have to make a decision, right? So this keeps really the arbitrator out of trouble as well, and that's part of our mission to expand access to justice.
Oh, thank you so very much. So you also mentioned about AI arbitrator. Can you tell us more, expand on how does this AI arbitrator, the process, how does it work?
Yeah.
Thank you.
So let's talk about first of all the caseload that's currently working with. So
Mm,
as it stands now, the AI arbitrator is in beta right now, and we are testing it with what we call construction fast track cases. These are construction claims that are under a certain dollar threshold. They tend to be the smaller claims. And we chose this caseload because a lot of the claims are very similar, and we have an incredibly large data set, if you will, of previous awards that we're basically using to train the AI arbitrator with. This is a great caseload to basically test because um, the results should be the most similar. And that's what the goal is with the AI arbitrator, right? No hallucinations, if you will. So the process is basically this. These cases would normally be handled as paper-only cases. Paper-only is just exactly what it sounds like. There's not actually an arbitration hearing with a paper-only case. Both sides submit their arguments on the papers, if you will, and a human arbitrator would basically review them and then make a decision. So the way the arbitrator is working right now is claimant submits their claim and supporting evidence, exhibits, whatnot. The respondent will submit an answer to that claim and with their uh, evidence and exhibits, right? And then the AI arbitrator essentially summarizes the information they've received from the claimant, and then summarizes the information they've received from the respondent, and then produces those summaries for the parties to actually review. So as a claimant, I'm basically going to look over the summary. I'm going to say, either the AI arbitrator correctly summarized the point I'm trying to get across, my argument, right, or it didn't. And if it didn't, you have the opportunity to correct it. Same thing for respondent. They're going to review their summary of their defenses and all that kind of stuff. And if the AI arbitrator was confused or something like that, they're going to have the opportunity to correct the arbitrator. Once the parties have made their comments and essentially signed off in an approvable form of the summary, then the AI arbitrator actually drafts an award. Now, the way it stands right now, because these awards are going to be binding, we're not just sending the awards to the parties and saying, hey, here's the award, right? Before the parties actually see the final award, a human arbitrator reviews the award just to make sure um, everything's in line and that nothing crazy happened with it. And if the human arbitrator feels that the AI arbitrator got it wrong or awarded too much, awarded too little, confused one of the claims, something like that, the human arbitrator has the authority to rewrite the award before it goes to the parties because ultimately the human arbitrator's name is what's going to be on the award, signing off on it. So they want to make sure it's all in order.
Oh, awesome, awesome.
Yeah, maybe I could ask two or three questions, Aaron, in the time we've
Yeah.
got. LLMs, you were using an LLM. Do you feel that gives the parties the ability to feel heard? Does that help with the delivery of a quality ADR service by AAA?
Yeah, I think it's extremely important for the parties to feel heard in the process. And again, especially with pro se litigants, who, might be frustrated with the process, not understand the legal process, think the process is somehow biased against them or rigged or something like that. And um, this essentially the AI arbitrator gives them that ability. And one major difference I would say between the AI arbitrator and necessarily or a human arbitrator is the AI arbitrator actually gives both sides the ability to review the summary, to review their notes, to review the work product kind of partway through the process, as opposed to in a traditional arbitration, um, the notes and the work product that the arbitrator uses to come up with their award are privileged only to the eyes of the arbitrator themselves. They don't share that information with the parties. And the simple fact that we're allowing the parties to actually review the summary of information before the AA arbitrator makes a decision, that's a whole nother level of being heard. And we also think it's going to reduce a lot of situations where, you know, the losing side will say, well, you know, I don't think the arbitrator understood my situation or understood my case or wasn't paying attention to what my arguments were. Well, by being able to review the summary, you'll know that the A arbitrator was paying attention to you because you could actually read the product right there.
Yeah, yeah. That's really interesting stuff, really interesting application of the
Yeah.
technology. Do you think the tool takes away the pro se claimant staying course? Is it?
This is a criticism from the dawn of time with arbitration in general, especially consumer arbitration.
Yeah.
And in the States, a lot of consumer arbitrations are relatively small dollar cases. If they weren't going to go to arbitration, they would end up going to small claims court. Some small claims court in the United States are very well run. You get to hear your case heard very quickly and you get a decision very quickly. Other small claims courts are backed up for months or even years.
Yeah.
When people say, well, hey, just having a robot or an AI arbitrator hear the case, isn't that sound a little impersonal, right? Or whatnot? Isn't this really taking away someone's chance to have their case fully heard, right?
Yeah.
And I would say this, because we're beta testing this, and we don't know what the full results are going to be over, after we've kind of reviewed all the awards and kind of seen how things are shaking out. I think it's really too early to kind of tell if it's going to favor one side over the other, or if the claim amounts are going to differ as if they were before just heard by a human arbitrator. And for folks in the consumer space, especially for some of these smaller consumer cases, who knows? Claimants might have a better chance at winning or a chance at winning more of their the claim that they're seeking. One thing that's really cool about the AI arbitrator is we were really conscious to make sure that there's no bias with it, right? And while I'd like to think all of the arbitrators we have on our panel are unbiased, and we do monitor people that are on certain caseloads that might have a lot of quote unquote repeat customers to make sure that there isn't something funny going on. In the end, it's very hard to tell somebody, even though this arbitrator has heard 13 different cases for the same respondent and issued awards in each of them, that they don't have some motivation to keep the respondent happy so they keep getting cases. It's hard to explain that to a claimant that's lost their case, right? But if the AI arbitrator is arbitrating their case, the AI arbitrator is just that. It's AI. It's not a person, right? So it's not motivated to go out there and get more business by appeasing one side or the other. So that's one thing that we really think is going to reduce bias as far as the perception of bias.
Yes. And power imbalances?
I'm sorry, imbalances?
Power imbalances.
Power imbalances, correct. It's gonna neutralize power imbalances, exactly.
Yeah. Interesting, very interesting. So why did AAA choose document-only construction cases for the beta?
Yeah, again, so we chose these cases because it's one of our cases with the largest existing data set, right, to learn from.
Yeah.
And it was very important for us to have a large data set to train the AI arbitrator on, and B, have cases that were all had a lot of similarities, if you will, between claims.
Yes. What guardrails do you think have been put in place to prevent this AI bias? Are you monitoring the outcomes from the arbitral awards?
Yeah, so the arbitrator doesn't have any information like access to like demographics, right? So it doesn't know if one of the parties is a man or a woman or your race or your religion or anything like that, right? And it doesn't retain any award information and use that information as precedent for its next case, right? So essentially every case is completely fresh, right? So it doesn't know who you are per se, and it's not looking at a former case when it's trying to like make a determination. So in that sense, it should be completely bias free, right?
Yeah.
Yeah.
But it's drawing out of the documents in its training principles
Yeah. Again,
rather than specifics.
it doesn't have any demographic information tied
Yeah,
to those
yeah, yeah,
principles.
yeah.
I'm just thinking about ethical issues with, AI and, how does the AAA sort of comb it or handle ethical issues that might arise?
Well, the ethical issues, I mean, what the human arbitrator
Mhm.
is a big part of the guardrails on that. And what I would say about this is the human arbitrator essentially goes through all of the same disclosure process they would if they were the sole arbitrator without some sort of AI tool
Okay.
on the case, right?
Mm.
So we know that the human arbitrator um, has disclosed to the parties previous cases they've been on with one or more of the parties or counsel that they might know, that kind of stuff. So essentially, the human should be completely unbiased, and the human has the ability to again overrule the AI arbitrator if the human feels that the AI arbitrator has somehow gotten something wrong or some sort of. I mean, I can't imagine it's an AI arbitrator. It's not a person, so I don't know how it would have any bias unless the bias was somehow programmed into it. But I'm sure we have guardrails against that kind of stuff.
How about the issues with privacy protections
Yeah.
as well?
Yeah, so so I think it's important to understand the difference between like an open source large language model versus closed source, right? So this is closed source, right? It's not chat GPT. So when parties put in sensitive information and all that kind of stuff, we're not selling that information or using it to train like other things, right? Um, and we along with this is one of the reasons at AAA, and this is something that's really cool that we did. We purchased for all of our arbitrators a license for ClearBrief.ai. I'm not sure if you're familiar with ClearBrief.
Mm.
Yeah.
So it's a case research tool essentially, because what we found were there were arbitrators that were using things like the free version of ChatGPT and stuff like that to do research on cases and things that they were working on. And as you know, ChatGPT pulls information from all corners of the web. It pulls information from Wikipedia, it pulls information from Reddit, it pulls information from all sorts of sites where people can essentially just make stuff up and put it on the internet. And that's why, a lot of these LLMs get things wrong or they hallucinate because the information that they're feeding from are incorrect. ClearBrief was a closed source um, LLM where if whether you're looking for a case to cite or evaluating the strengths of existing cases that someone's using in their briefs, the only thing that ClearBrief is trained on is the cases that have been put into ClearBrief per se. So it can't create a fake case or something like that, which has been a problem in the U.S. court system. You guys have probably heard about situations where judges have caught somebody in a brief with a case that never existed, right?
Yeah, we have that in the UK too.
You have that in the UK too, right? I mean, and
Yeah, yeah.
it's worse than that because a lot of these cases, not only are they fake cases, but they have fake Westlaw citations, right? Or fake Lexis citations, right? So it's the open source LLM has gone a whole step further and created a fake citation number, right? So again, closed source are the AI arbitrator is closed source, just like ClearBrief, which a lot of our panelists now use as closed source, and that really reduces the chance of hallucinations. I'm not saying that the tool is 100% hallucination free. That's
Yeah.
why you still have a human being reviewing the work.
Mm.
But it should be pretty darn close to hallucination free.
So, Aaron, the direction of travel with the tool is the plan for arbitration AI to replace humans completely? Will the humans come out of the loop? What's the thinking? Are you able to reveal the thinking?
So I think we'd like to get the AI arbitrator to the point where maybe we don't need a human to review all the results, because in the end, the AI arbitrator is supposed to be um, a faster, more cost-efficient way to resolve things than having a human arbitrator, and it's going to cost the parties a lot less money using the AI arbitrator. Now, if you're asking if the AI arbitrator is going to get rid of human arbitrators altogether, I would say definitely not. I think you have to look at you can arbitrate just about anything these days, right? And particularly with large complex cases that have very unique fact patterns, right? That might not be similar to other cases out there that an AI arbitrator could study. Um, I don't really see in the near future the AI arbitrator ever replacing, those types of arbitrations.
So it's really ideally suited for, would you say, lower value, more frequent fact scenario type cases? Is that the plan?
I think lower value, at least to begin with, right? Because I think there's less controversy with lower value cases. But I think what you said, the second part of what you said is probably the most important. Frequently reoccurring fact patterns, right?
Yes.
Because again, when you have frequently occurring fact patterns, that's where AI really shines when it comes to disseminating information.
Yes. Yeah. Thank you.
So why is AAA in such a position to create or develop this technology? What why is AAA a unique position to develop this technology?
Well, as one of the largest ADR providers in the world, we also have some of the largest case data sets from previous cases. Now, we have a document destruction policy here at AAA. We don't keep the entire award for every single award we've ever issued over the last 99 years, right? But we do enter in information as far as what the original claim was, maybe the number, right? How much was awarded on that claim? Was there a counterclaim? We keep information like that, right? And not necessarily tied specifically to specific parties or party names or anything like that, but just overall tracking, those types of trends. Also, smaller things like was a dispositive motion filed in a case? Was a dispositive motion granted? Did the parties decide to mediate at any point during the arbitration? We have a mediation step here, right, where we encourage parties to find a way to resolve their dispute prior to the evidentiary hearing. That's ultimately the way that makes the parties the most happy, anyways, right?
Sure.
So things like that. So because we have these large data sets, and because we're as a nonprofit, we're a very public institution. Um, Everything from the AAA's tax return to our case filing figures and things like that, it's all public knowledge, right? As a nonprofit, we don't. There's no secret here. We don't have any shareholders, right? So um, you can basically find out everything you ever want to know about AAA just through Google or visiting our website because we publish a lot of this information on the website.
That's great. Well, we've got a couple of 3 minutes left, Aaron. Our time's been too brief, to be
Yeah.
honest. I just wondered if you could share perhaps something along the lines of what advice you now would give to young arbitrators coming up and hoping to take advantage of the wonderful AAA facilities you've got going on there.
Well, so do you mean in the sense that people that are looking to become mediators and arbitrators, what advice do I have?
Yes.
Yeah,
Yes.
sure. Yeah, so I get asked this question a lot, and I'll try to summarize it kind of in 3 minutes. It might take a little bit more time than that. But I always like talking to younger folks that are interested in careers in ADR. And a lot of the people I talk to are either still in law school or just have recently come out of law school, and this is something that they want to do.
Mhm.
And my advice is you should spend a couple of years as a litigator at a law firm. And if you're interested in becoming a mediator, see if you can do something more than just draft the mediation brief for the partner to take when they go to the mediation. See if you can actually tag along to the mediation. Start
Yeah.
shadowing mediators. Um, Watch how the parties negotiate and all that kind of stuff. This is mediation is one of these things I think you learn a lot by shadowing others, right?
Yes.
Um, and with arbitration, I would say the same thing. A lot of associates at law firms, younger associates, are drafting the complaint. They're drafting the answer. They're filling out conflict check forms. They're doing all sorts of stuff behind the scenes, but not a lot of them actually make it to the evidentiary hearing, right? Um, it's the partner or the more senior attorney that actually argues the case.
Sure.
You might not get a chance to do this as a first or a second year associate, but maybe as a third or a fourth year, see if you can start second sharing arbitrations, if you will. Observe the arbitrator, observe counsel, observe how witnesses are questioned, things like that. Um, and that's really the best kind of training you can get for a career in arbitration. To join the AAA as an arbitrator, we do have, requirements on how many years of, practice you would have if you were an attorney, or how many years of professional experience in general. One thing that a lot of people don't realize is that AAA, we have a number of people that aren't even attorneys or retired judges. We have subject matter experts here at AAA. So, for
Yes.
example,
Yeah.
let's say you arbitrate construction defect cases. Well, you
Hmm.
might not be an attorney, but you might have a background as a professional engineer, right? And
Yes.
you know everything about construction defect engineering failures because you're an engineer, right?
Yeah.
Let's say you do accounting malpractice, right? Well, maybe you're not an attorney, but you have a CPA, right? You're a certified public accountant, right? So you know just about everything there is to know about accounting. So whatever profession you go into, whether you go into the law or you go into some other profession, there's probably a path to becoming an arbitrator through whatever it is that you're doing, but you have to become a real expert at what you're doing, and you have to show people they're
Yes.
going to have to pay you, potentially a
Yes.
lot of money, right? Depending on the case type,
Yeah.
that you have, a lot of experience in that practice area, and that you understand what you're doing. I think it's very hard. Unfortunately, I have a number of folks that apply to be on the AAA's panel that maybe come from a transactional background, right? They've never actually litigated a case. They've never litigated a case in court. They've
Yeah.
never done an arbitration. They just kind of drafted and reviewed contracts their entire career. It's really hard for people like that to have success, not because they couldn't learn to be an arbitrator, but because the parties ultimately select who arbitrates their case, and it would be very strange for them to select somebody with that background over somebody that has an established litigation background. Other advice I give young people, especially in the mediation space in the States, and I'm sure it's like this in England as well, there are tons of volunteer opportunities to mediate disputes, both in the court system and outside the court system. Just about every court in California, where I'm at, requires the parties to do what's called an MSC, a mandatory settlement conference,
Uh-huh.
before a case can actually go to trial. Sometimes the mediator in the mandatory settlement conference is a judge, not the judge that's going to be presiding over the case at trial,
Yeah.
but some other judge. But oftentimes, it's what we call a judge pro tem, somebody who's not a judge at all, but is basically doing a volunteer mediation for the court. And if you start doing those cases, which are relatively low stakes in the sense that you're not getting paid to do the work, no one's going to be upset at you if the case doesn't settle. If you start doing those cases and you start having success actually settling them, attorneys are going to start to remember who you are, and they might entertain using you for a future mediation as a paid mediator, right? And that's another
Yeah.
really great way to start. Um,
Yeah. 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 I often get asked a similar question by those seeking mediation work, and the key thing I think I pick up on is expertise that you've mentioned,
yeah,
because essentially we're talking about developing a business, the
right.
business of being an arbitrator or a mediator, and expertise is one of the key things. Experience.
And I'll say this too, and I think there's a misconception that a lot of people have that you really need to be on a provider's panel to have any success in the mediation arbitration space. Um, there are plenty of ad hoc mediator and ad hoc arbitrators out there that are not affiliated with providers that have a lot of success. At the same time, there are plenty of neutrals that are affiliated with provider panels that don't have a lot of success because they don't really put any work into marketing their practice and learning the business. Just like you said, it's about sharpening your skills, getting out there, letting people know that this is something that you're doing. I liken it to a little bit like being a realtor in the United States. Most realtors are it's a commission only profession. Some people do it part-time. Some people are very successful at it. Some people aren't. It's ultimately something you get out of what you put into, right? And if you really hustle out there, you get clients, you do a good job selling houses, you're friendly and personable, and you have repeat business and all that kind of stuff. That's really should be what your goal is as a neutral as well. Um, Essentially establishing yourself in a marketplace. You want to be an expert in what you do, but you don't want to be so narrow in some strange field that you can't get any cases. But you also don't want to be so broad as seen as a jack of all trades who might actually not be an expert in enough things. And I've said this before. Mediation to me, mediation is something that certain people are just born to do. We all know people that are just natural peacemakers. These were the kids on the school playground growing up that wouldn't start the fights. They'd be the ones that would step in. They would break up the fights, right? Arbitration, I think, is less a natural skill. I think arbitration is something that can be learned, and I think arbitration is something that is largely tied to whatever your profession was or whatever your practice area was as an attorney, and just becoming really good, an expert in that practice area. So that's my advice to young people.
Oh, thank you so much.
Sorry, Chinwe, go ahead.
Sorry, we just have a few minutes to go. Just to say thank you for your perspective and insights. Tony, you can go ahead. Sorry, just in case.
I just wanted to ask my final question.
Yeah.
It's been really interesting talking about the AAA's AI initiative. Is it intended, after a period of time, that the AAA will publish an evaluation of what worked well, what didn't?
Yes, I think, like I said, I don't know 100% the answer to that question because I don't want to hallucinate and give you the wrong information. But I'll say this: if there's any institution that would publish a study about what worked and what didn't, it would be AAA because we publish studies and public numbers on all sorts of things, right? Since we're not a private for-profit institution, we feel, I guess you could say, a greater need to disclose to the greater public, right, as a nonprofit, what it is we do here, and how we operate.
All right. Thank you, Aaron. Thank you so very much for coming on this show. We are so grateful. I just have one more question. Is there any disadvantage associated with the AI tools and AI arbitrator?
So you say it one more time?
Any disadvantages associated with AI tools and AI arbitrator?
I mean, like I said, I think it's too early to answer that question. A lot of these things